Welcome to Husch Blackwell's Labor Law Insider Podcast. This is your host, Tom Godar. I've been practicing in the labor law sector for, more than 40 years, and I can tell you that in no time of my practice has labor law had greater changes than in the last 5-6 years. We began the podcast in May of 2021 following the election of President Biden, and the elections have consequences, and under the Biden administration, a new National Labor Relations Board with a new general counsel reshaped labor policies, and they were very consequential. During that time, because it was so important to stay on top of labor law issues, the family of Husch Blackwell Labor Law Counsel more than doubled in its coast-to-coast reach to assist our client. Well, we've since had another election. In the January of 2025, President Trump was inaugurated to his second but non-continuous term. And once again, we're seeing significant changes in how the National Labor Relations Board and its appointed members, the GC right now an acting general counsel, and the board members are going to interpret the National Labor Relations Act and its associated laws. So once again, we're continuing a wild ride of labor law. It's not likely to change soon, so buckle up and enjoy the Labor Law Insider Podcast. Marianne, it's great to have you back for part 2 of the Labor Law Insider Podcast. In part 1, we introduced and had a great discussion on how the recent acting general counsel's memorandum regarding settlements and the features of them is going to change opportunities actually to arrive at settlements and what must be included. We talked a little bit as we ended part 1 about default language, which used to be a necessary part of any settlement agreement, or nearly so. And we are also talking a little bit about non-admissions clauses that basically disappeared under the Abruzzo regime as general counsel in any settlement agreements. But I think they're going to make a reappearance for the management side as we discover how to navigate through resolving ULPs long before they go all the way through trial. So, Marianne, tell us what that is within the context of a settlement in the National Labor Relations Board claim and how it's changed under Cowen's direction compared to that which had been under Abruzzo's admonition to her team at the various regions.
Sure. So non-admissions clause, the name basically speaks for itself, right? As defense attorneys, when we settle any type of litigation, whether it be at the board or, discrimination case or whatever, we always insist on behalf of our clients that language be put into the agreement that the employer is not admitting that they have violated the law, that by entering into the settlement agreement, they are not admitting that what they have done is, has discriminated against employees or violated employees' rights under the NLRA. Because again, at the point in time you're settling, there hasn't been an adverse finding against the employer. So of course, you want to make clear that by settling this, I am not, the employer, I am not saying that we did anything wrong at this point in time. Abruzzo took the position against including those types of clauses in settlement agreements. And it was very difficult to get regions to agree to that type of language, if at all. And then, this new memo issued by Cowen basically rolled that back, did not take as stringent of an approach. And basically now it says, regions do have the ability to consider those clauses in settlement agreements. Obviously, again, case by case basis, if there's a repeat violator, the region would probably reconsider that for those types of employers. But, for the most part, the employers that we're representing aren't repeat violators. So it's really not an issue to include that language in there.
Well, someone could certainly argue that a common thread is that this is more friendly to a management position. But if you're working day to day in the board, as some of our colleagues have in the past, this also restores in some way discretion to some very hardworking, very smart people who have found themselves in the position of regional director or assistant regional director in the regions. That is, they're going to look at this as a case by case. They're going to say, what's the strength of our case? How far can I really push on this in terms of what we've discovered so far? It might have to do, I suppose, with how much investigation the board has done, how carefully and clearly they can articulate to management council, hey, we're going to win. We're going to win big if you want to go forward. So we can demand a lot. But if they can't say that, it's harder to, insist upon remedies that may be a stretch even before an administrative law judge who might not include any of these kinds of sort of directions in his or her order. It's fascinating that in some ways I see this as really a return to some discretion and some real valuing of the strength and weaknesses of cases.
Yeah, this new memo is really about being pragmatic and not seeking perfection, perfection in 100% back pay, reinstatement, all those compensable damages. It's like you said, the quote that I think we've seen, everyone who discusses this memo discusses this quote: if we attempt to accomplish everything, we risk accomplishing nothing. And I think that was the risk of Abruzzo's position, where that employers just shy away from entering into these settlement agreements at all, which could potentially be to the detriment of the alleged employee discriminatee if they end up, losing at a board trial. One purpose of the act is labor peace. So emphasizing efficiency, flexibility, and analyzing these issues in these cases individually versus getting 100% remedy and everything else under the sun that you could think of that touches on that alleged ULP. Settling cases, I think, is more beneficial to the purpose of the act than taking such a hard line approach.
It's interesting. I before we got together, I looked online and tried to get a barometer of what percentage of those cases there are that make it to a place of finding that the board is going to move forward, and which of those are settled. And it's still about 90%. I mean, gosh, I learned that back in law school and whatever that year was, that most of the cases filed don't go to trial. Most are resolved in litigation motion, that is civil litigation. But even before the board, once they get past the bringing a charge, get to the complaint stage, that most of those are settled. So this is a big deal to be able to have what might be thought of, at least on our side of the bar, as more common sense settlement. And it might actually deliver certain amounts of justice, if you will, to those who have brought a worthy unfair labor practice on the union or individual side to get to a resolution. When you say, yeah, we can maybe win in 3 years, that's not really much of a win for some people. The memo continues and talks about the Thryv case, which was a big deal in 2022, where the board expanded the remedies. And you've already touched on that a bit. How is this going to challenge, from a practitioner's standpoint, the idea of some of the ways in which we describe burdens of proof or foreseeability? How is this going to take away some of the sting of the Thryv case, or at least as the management council and participants in this saw that sting?
Yeah, so, Thryv still remains good law, right? Good board law. And as you mentioned earlier, board, or I guess now, again, former board member Wilcox, the on-again, off-again board member. So now currently the board lacks a quorum. So for the time being, although we anticipate down the road, however long this may take, board precedent will likely shift under a Trump board. And, many of those sweeping decisions that were issued over the past few years will probably, swing back to maybe a more employer-friendly standard. That's not happening necessarily anytime soon. So Thryv is still good law. And, the key point of Thryv, the board said that employers must compensate employees for, quote, all direct or foreseeable pecuniary harms. But if my memory serves me correctly, I don't think they were very clear as to what the term, foreseeable meant. Obviously, that is a term grounded in tort law. And again, when you take that case coupled with Abruzzo's position in her earlier GC memos about, compensatory damages and the examples she was giving, one example of an actual settlement agreement that I think her regions during her tenure got was the employee lost their job. So they lost access to areas or the facilities to express breast milk during the workday, which resulted in the employer in the settlement agreement agreeing to compensate that employee for formula costs. To me, that just seems such like a tenuous connection. that how could that possibly be foreseeable? I don't know. To me, it's a stretch. An employer agreed to it. It is a victory that she cited in one of her memos, but it's that kind of slippery slope that I think Cowen's current memo is trying to pull back the reins a bit. Again, Thryv is currently board law, but Cowen in his memo that was issued in mid-May basically highlighted the dissent's point of view, where only harms with a sufficiently clear causal link to the ULP should be remedied. So this, is a narrower viewpoint of that standard in order to avoid those ambiguities. So for our listeners, a GC memo is not law, right? It is guidance, and it really is shedding light on what the general counsel's policy agenda is going to be and what their prosecutorial focus is going to be. So although Thryv remains good law, I think we could see that the regions are going to take a more narrower approach as to what cases they prosecute or what remedies they seek in terms of unfair labor practices. So it's an interesting, position that we're currently in, where we have this one case that is legal precedent versus where we anticipate or where we see the general counsel is going to go based on this new memo. Because when I was looking over my resources to prep for our conversation today, I was like, okay, what would be a clear causal link? Because under Abruzzo, what if I lost my car because I couldn't pay my car note for 2 months because I lost my job? Theoretically, when you get so behind on a car note or your mortgage, it's months and months and months. So how could that, me losing my car, be attributable to my employer at that point in time when theoretically I was probably behind for months and months prior when I still had a job?
Well, and if you talk about buying formula for 6 months, you have to write a check. It's real. I have a new grandson. I have had conversations with my son and daughter-in-law. It costs money. But it's not like if you can't pay for or choose not to pay for insurance, and then you have $100,000 ER and a hospital visit. Would that be foreseeable? Was it, you say, well, a certain number of people have traumatic episodes in their life that call for medical intervention that should have been foreseeable and causal. So, yeah, it's not really easy to have known what that meant, is it?
No. So I think now with this whole causal link that is sufficiently clear language, we could narrow down what we anticipate the remedies the region would agree in these settlement agreements versus, everything under the sun potentially was game with the prior general counsel.
And we have some terrific clients who oftentimes have really excellent defenses to a claim that they're engaged in a ULP, even if it's brought in good faith by someone not just in a power distribution issue. But if it's going to cost $50 or $100 or $150,000 to move it towards litigation, we certainly talk with the client as to whether or not they might be interested in settling in that. And in this day, when there isn't a board quorum and we only have a general counsel nomination, not even a hearing set, nor even others identified to take the role of board members, folks are going to say maybe I ought to settle. And then we'll add to that we're going to lose, I think the report was just 3 or 4 days ago, that the National Labor Relations Board as an organization is going to lose about 100 employees. That would presumably make the process slow down a little bit more. There's good reason that employers, individuals, and unions will look to resolving differences without having to go through all of the litigation. And I'm hoping that this memo allows everybody to be creative and thoughtful as they move forward and saying, what's the best we can do for our respective clients these days to move forward. I'm hopeful that this kind of memo will spur that creative, careful thought.
Agreed. I think discretion in this case on the part of the regions is a good thing. It balances fairness as well as efficiency. And like you said, with the layoffs, the board and the regions are busy enough. As we know as practitioners, the timeline for cases and ULPs from start to finish is getting longer and longer. So it's, this memo seems to potentially open up that backlog and give regions more discretion, which may be more palatable for employers, as well as, provide faster resolution for employees. Because again, to the everyday person, waiting 3 or 4 years or 5 years for something to wrap up like this is, not ideal for them as well.
Nope. Well, listen, man, that's been really terrific to sort of get our heads wrapped around some of these changes, some of the impact practically that we're talking about, as well as some of the nuances in terms of what foreseeable might mean, for instance. So I thank you so much for joining us. I'm sure you'll join us again in the future, but that time I suspect I'll be talking to you in New York. And so I wish you and your family a good move. And the whole idea of moving just freaks me out. So better the you than I, but I hope it goes well. And thanks so much for joining us on the Labor Law Insider podcast.
Yes, thank you, Tom. Have a good day.
All righty. Bye-bye.